Hi everyone, you're watching the Virtual Amicus and I'm Jay Ludha. So today's topic for discussion is very interesting. It is on defenses that are available against recovery proceedings by banks and financial institutions. So we will be dealing with defenses that are available to the borrowers or what we call defaulters under the provisions of Insolvency and Bankruptcy Code, then RDB Act, which is also referred to as Recovery of Debts due to Bank and Financial Institutions, etc. and etc. So we've seen that we all are in the middle of a pandemic, and we've seen day in and day out recovery proceedings that are being initiated, recoveries being initiated against the borrowers, defaulters for some reason or the other. Now, what are the defenses that are available in that case to a person who was defaulted or to an institution that has defaulted? So to have to assist us better and to seek further clarity on this subject, we have with us a promising young lawyer. We have with us, who's the amicus for today's session, Mr. Rachit Sharma. And just to give you all a brief introduction about our amicus for today's session, Mr. Rachit Sharma pursued his law from University of Rajasthan back in 2017. Prior to that, he finished his company secretary from the Institute of Company Secretary of India in 2015. And he also holds two additional qualifications. One, certification in intellectual property rights from World Intellectual Property Organization, and two, certification in computer training from Aptech. Now, prior to joining Mr. Vein Luda Learned Senior Advocates Chamber, he worked at Vedanta Law Chambers, where he acted as legal advisor and did due diligence for companies offering initial public offer, which is the IPO, further public in the field of textiles, of fertilizers, electric cables, etc. He's also done corporate restructuring, due diligence of prospective investee companies, including risk analysis in the case of private equity investment and compliances as per the Companies Act. He's also drafted various company petitions, applications, replies, rejoinder under provisions of Insolvency Bankruptcy Code, SARFAESI Act, RDB Act, etc. And he's also has had frequent appearances and has drafted various representations and replies to show cause notice by Enforcement Directorate under FEMA 1999, the Registrar of Companies, RBI, etc. and etc. So thank you so much there, Mr. Rachit Sharma, for taking out time. And the stage is set. The floor is all yours. Over to you.
Thank you so much, Jay, for this nice intro. And thank you for inviting me to your channel, The Virtual Amicus, and giving me the opportunity to discuss on a very important topic that deals with what are the defenses and what are the do's and don'ts that are available with the borrower as well as the guarantor against the recovery proceedings initiated by these banks and financial institutions. So as you all know that in today's scenario of COVID-19, the micro as well as the macro sectors of the economy has been severely impacted, which has a corresponding effect on the industries, resulting these industries and the businesses could not able to meet out their fixed expenses. Particularly what I am dealing with in today's presentation is relating to the non-payment of the borrowings that they have taken in the form of principal and interest. So before moving forward, what we need to understand is that whatever the money that we have taken, we have to give back to the lenders from whom we have taken. We are not here to discuss about the curtailment of rights of these banks and financial institutions, for the reason because this is their statutory right to demand amount from the borrower, because this has been the right has been given from by way of various enactments, act, rules and regulations and other notifications and circulars issued by Reserve Bank of India from time to time. But how the borrower can ensure that the banks must adhere to the rules of procedure, because banks these days have the tendency to adopt some unusual means of recover dues from the borrower. So now back to the topic. If in case there is a failure by the borrower, then generally what we are discussing, what we have seen, that the banks and the financial institutions take actions under four heads or under four laws, we can say. So I'm sharing my PowerPoint presentation before you. So as you can see on the screen, these are the four heads. That is the number one, by way of assigning of their loan application to the debt collection or recovery agents for the purpose of recovery. Second, SARFAESI Act, that is the Securitization and Reconstruction of Financial Assets and Enforcement of Securities Interest Act 2002. Its jurisdiction lies with Debt Recovery Tribunal. Third, RDB Act, that is the Recovery of Debts Due to Banks and Financial Institutions Act 1993. Its jurisdiction lies with DRT. And the fourth one is the recent enactment, not the recent, but the last and the latest one, that is the Insolvency and Bankruptcy Code 2016. Its jurisdiction lies with National Company Law Tribunal. So, next slide, that is the defenses against the unruly behavior from the recovery agent. So, as you have seen that particularly in the form of in cases of the unsecured loans and the loan where the quantum of amount is not so big, in those cases the lenders often take the help of these recovery agents to threaten borrowers to repay their loans. So how we can ensure against the unruly behavior from these recovery agents? So for this, the Reserve Bank of India has laid down the Fair Practice Code, that is the Banking Codes and Standards Bureau of India, which is an autonomous body of banks. So this Fair Practice Code lays down the boundaries within which these recovery agents have to carry out their operation of recovery. Like in this Fair Practice Code, you can ensure that what are the boundaries that are set by this code is that like the agent which come to your house or your workplace must be authorized by the Indian Institute of Banking and Finance. Their names must be available on the websites of banks, and their all the details must be available with the branches. They can meet with the borrower only at the specified times during the day only. So they cannot violate norms of decency and civil behavior during their visits. They have to maintain the level of decency and civil behavior. And whomsoever the recovery agent who is coming to your house must carry the identity cards and authorization letter. So these are the things, and other terms and conditions are defined under the Fair Practice Code, the boundaries that are set for these recovery agents. So if you are like feel harassed by any recovery agent, then you can lodge the complaint to the bank, and bank has to mandatorily redress your grievance within a period of 30 days. And if the complaint is not addressed to your satisfaction, you can lodge the complaint before the banking ombudsman under the Banking Ombudsman Regulation Scheme 2006, or you can also lodge the complaint before the nearest police station. You can also file the injunction suit against these banks and financial institutions. So moving forward, now if in case if you have taken any amount and if any security interest has been created against the borrowings that you have taken, then banks generally tends to invoke the provisions of SARFAESI Act. So whenever you are in default and any security interest has been created, then you may be served the notice under section 13 subsection 2 of the SARFAESI Act. So this is the first step that the banks usually do to the banker. So if suppose you are a borrower who is under a liability to a secured creditor makes any default, so you have to make any default in repayment of secured debt, and his account in respect of such debt is classified as a non-performing asset. So this is a compulsory condition that first your account must be classified as a non-performing asset, then only notice under section 13 subsection 2 can be served upon the borrower. So as you all know that what is a non-performing asset? A non-performing asset is a loan or advance for which the principal or interest payment remained overdue for a period of 90 days, and then thereafter it may be further subclassified into substandard, doubtful, or loss assets. So the first condition, that is classification of account as an NPA, then thereafter the secured creditor may require the borrower by notice in writing to discharge the liability within a period of 60 days. So this is a statutory time period that should be prescribed under the notice under section 13 subsection 2, with an indication that if he fails to do so, the secured creditor shall be entitled to exercise all or of any of the rights in terms of section 13 subsection 4. So if the borrower is unable to pay the debt within a period of 60 days, mandatory 60 days, then the lender can take the action under section 13 subsection 4. So now I will refer the section 13 subsection 4, that what are the actions that can be taken by these banks. That is, like they can take the possession of the secured assets from the borrower. They can take over the management of the business, or they can appoint any person to manage your secured assets, or they can also require at any time by notice in writing any person who has acquired any secured asset from the borrower and from whom any money is due. Now suppose if any security interest has been created in favor of the bank, and that security interest in the form of any asset has been transferred to any third purchaser, then the bank has the power under section 13 subsection 4, requiring that third person to pay the remaining amount of debt to the lenders. So they can initiate action under section 13 subsection 4. So now there is also an essential condition that we have just talked about relating to the classification of a non-performing asset. So there are judicial pronouncements which says that, like, temporary deficiencies like late or non-submission of stock statements, or balance outstanding exceeding the drawing power, or non-renewal of limits should not get categorized as a non-performing asset. Then in that situation, your account cannot be classified as a non-performing asset. So 13 to notice is basically the first opportunity of being heard which is provided to the borrower. That is under section 13 subsection 3a, which lays down that the borrower may make a representation in response to this notice. So whatever are your counter, whatever are your defenses, when now suppose, like, if I'm challenging the NPA classification, if I'm challenging the quantum of amount, if I'm challenging the applicable interest rate, or like any violation of the terms and conditions of sanction letter or any contractual obligation, then I should counter that by way of reply to the 13-2 notice. And the banks are required to give the response of the reply within a period of 1 week. And what you need to understand as a borrower, that upon receiving of the 13-2 notice, you cannot approach before the DRT, because it will not confer you any right. So, as already held by the Honorable Madras High Court in case of D. Ravichandran versus Indian Overseas Bank on 2nd of February 2006, which was held that the notice under section 13 subsection 2 of the Act is really a show cause notice, and ordinarily this court does not interfere with show cause notice, and this court, not the High Court and even the DRT, because your right has not been impacted just upon receiving the 13-2 notice. So these are the things that you have to take care of. And one more a word of caution in there, that upon receiving the 13-2 notice, because the provisions of SARFAESI Act has been invoked by the banks, then there is a word of caution, and that has already been laid down under section 13 subsection 13, which says that no borrower shall, after receipt of notice under section 13 subsection 2, transfer by way of sale, lease, or otherwise any of his secured assets referred to in the notice without prior consent of the secured creditor. You are not supposed to transfer that secured asset to any third borrower. So for the purpose of frustrating the proceedings taken by the bank under the provisions of SARFAESI Act. So moving forward, that is, upon receiving the 13-2 notice, now suppose you fail to repay the amount that you have taken from the bank. A bank will carry out the proceedings under SARFAESI Act. They have a right to auction the property. So, as you all know, that under the SARFAESI Act, at the time of auction, the bank has either symbolic possession or physical possession of the property. In symbolic possession, the bank generally puts the notice on the main entrance of the property or residence, and photographs are being taken in the presence of 2-3 bankers showing this symbolic possession. Thereafter, taking the possession of the property, bank proceed with the auction process. So this auction proceedings, what you need to ensure that whatever the property that is put for auction must be fairly valued. If that is undervalued, you can challenge it before the Honorable DRT. And whatever the assets that is put for auction, prior to that, there must be an advertisement in the newspaper by the banks, which and in the newspaper they have to specifically provide all the details of the movable as well as the immovable property details in the said advertisement. and and if in case, now suppose if you do not have a sufficient amount to redeem the property, then you can also have an arrangement with other financier who can participate in the auction process, and you can also propose for the settlement before the bank. And furthermore, like now, if they have taken the possession for the purpose of ensuring the auction proceedings, this can also be challenged, but only in rarest to rare circumstances. Now suppose if your security interest is in the form of a house property and you are residing in that house property, then you can seek additional time from the Honorable DRT, like for the purpose of repayment of borrowings that you have taken, or like if your security interest is in the form of a factory or an industry, and workers and employees are working in their industry, then you can also seek time. So in this way, you can ensure that these banks can adhere to the rules of auction that is prescribed under the SARFAESI and its rules. Next, point number 4, that is right of redemption and possession. So before this, you have to understand that there are 3 stages in auction. Number 1, when, like, upon receiving of 13(2) notice, they can take action under section 13 subsection 4. Thereafter, they can carry out the auction of the proceeding. Thereafter, they can declare the successful bidder. Thereafter, upon declaring the person as a successful bidder, they can issue the sale certificate to that bidder. And upon issuance of sale certificate, that sale certificate need to be registered before the office of sub registrar office. So these are the 3 stages: auction, issuance of sale certificate, and thereafter registration of that sale certificate before the office of sub registrar. So these 3 stages are very important for the purpose of ensuring the right of redemption and possession. At what stage you can exercise this right of redemption and possession? So there are judicial pronouncement which says that at any time before the sale confirmation and registration of the property, this is a statutory right available with the borrower, that you can redeem your property and take back the possession upon repayment to the borrower of the outstanding amount. And even after, there is an exception which is provided that even thereafter the confirmation of sale and registration of the property, you can redeem and take the possession of your property, but they need to prove the involvement of fraud in the whole process. Otherwise, neither the DRT nor the Honorable High Court will entertain you for the purpose of redeeming and taking back the possession of your property. So moving forward, now 5th, that is the borrower's right of appeal. Now this machinery of appeal is provided under section 13 subsection 4 and under section 14, when the borrowers can file the application under section 17 before DRT against the measures which were taken against the borrowers. So under section 17 subsection 1, the expression which is used, that is any person. So any person includes not only the borrower but also the guarantor. or any other person who may be affected by the action taken under section 13 subsection 4 or under section 14. So now suppose if in an industry any employee or any worker is involved and the banks have taken the symbolic, or if the bank has taken the possession of that particular industry, so because of the problem of unemployment of that particular worker or workers, they can approach to the DRT under section 17 because the expression used is any person. So they have to approach it before the honorable DRT. So in the case of, so next slide, so the Honorable Supreme Court in the case of United Bank of India versus Satyavati Tandon decided on 26th of July 2010, in which the powers of the DRT were decided, in which it was decided that the tribunal and the appellate tribunal are empowered to pass interim orders under section 17 and 18, are required to decide the matters within the fixed time schedule. So if any matter is lingering upon, like for 3 years, 4 years, then you can refer this judgment. Next is the right of the bank is not automatically suspended upon filing an application by the borrower under section 17 of the act, and secured creditor can proceed further in the matter where no stay is granted. So you need to ensure that to take the stay against the recovery proceedings of these banks and financial institutions. Next is the tribunal has the power to impose the condition relating to deposit for grant of stay of auction, and that generally range from in DRT Jaipur like 10% or 15%. They order for depositing it before the honorable DRT, and whatever the grounds which render the action of the bank as illegal should be raised in that proceeding. And what you need to understand is that the tribunal has no power to pass any interim mandatory order relating to restoration of possession before finalization of the proceeding under section 17 of the act. They can pass the interim stay, but they cannot pass any order relating to restoration of possession. That can only be passed upon the disposal of the application filed under section 17 by the banks, by the lenders. So moving next. So if you aggrieved by the order of the DRT, you can also file an appeal to the appellate authority within a period of 30 days from the date of receipt of order. And there is a precondition of filing an appeal before the DRT that you have to deposit the 50% of the amount debt due, which can be reduced to 25% on showing sufficient reason. And there is also a note that you can see on the screen, that is the jurisdiction of civil court has been clearly barred under section 34 of the act, stating that no injunction can be granted by any court or other authority in respect of any action taken or to be taken under SARFAESI Act or the DRT Act. So you cannot file any application before the civil court because a specific machinery has been created by way of enactment under SARFAESI Act as well as under the RDB Act. So you have to invoke the provisions of SARFAESI as well as the RDB Act only. You cannot go to the jurisdiction of civil court. So now if you are affected by the actions of these banks, then you can either approach DRT, DRAT, and also under one of the under the circumstances that is prescribed by the Honorable Supreme Court, that when you can invoke the writ jurisdiction, that was very clearly laid down by the Honorable Supreme Court in Commissioner of Income Tax and Others versus Chabil Das Agarwal. So these are the situations under which you can invoke the writ jurisdiction. Number one, that is when the remedy available under the statute is not effective, but only a mere formality with no substantial relief. Second, where statutory authority has not acted in accordance with the provisions of enactment in question, or where statutory authority acted in defiance of fundamental principles of judicial procedure, or fourth, where statutory authority resorted to invoke the provisions which are repealed, or where statutory authority pass an order in total violations of the principles of natural justice. So under these circumstances only, you can invoke the writ jurisdiction, otherwise not. So these are some of the possible defenses that I've discussed with you under the provisions of SARFAESI. Now I am coming to the action that is taken under the provisions of Insolvency and Bankruptcy Code. So under the Insolvency and Bankruptcy Code, now the essential condition to invoke the provisions under the IBC Act that is provided under Section 7 is that there must be a financial debt. There must be a financial debt, and the debt must be due and payable. So the Section 7 provides for a statutory right in favor of the financial creditor to initiate the corporate insolvency resolution process of a corporate debtor on the occurrence of a default. So we need to understand what is default, what is financial debt. So I'm referring the definition of Section 13, Section 3, subsection 12 under the provisions of IBC, which defines the default. Default says that as non-payment of debt when whole or any part of installment of the amount of debt has become due and payable. So there is a essential condition that the amount must be due and payable. Now suppose, being as a borrower, I have taken the loan of rupees 10 lakh from the lender for a period of 5 years. So before the expiration of a period of 5 years, the lender has demanded the amount of rupees 10 lakh. Suppose on the first year itself, they have demanded the amount. So I have denied to repay that amount, and they have initiated the action under Section 7. So I can counter that by saying that the amount is not become due and payable. The amount become due and payable only upon the expiration of a period of 5 years, not on the first year. So it must become due and payable. And what is the another essential condition is that there must be a financial debt. Now, what is a financial debt? So that is defined under Section 5, subsection 8, which says that a debt along with interest, if any, which is disbursed against the consideration for the time value of money, and that includes the money borrowed against the payment of interest, which simply means that the financial debt that is defined under the provisions of IBC Act considers the time value of money. There must be an ingredient of interest into it. If interest is not included into it, then it is not a financial debt. Section 7 cannot be invoked by the lender under that situation. Now, suppose if I have extended any deposit, interest-free deposit, then I cannot invoke, then being as the lender, I cannot invoke the provisions of Section 7 because there is no interest factor into it. So there must be an interest into it. Then only the said provision can be invoked. So as also laid down by as also laid down in Jagdamba International versus Viva Powertech Private Limited by the learned NCLT Mumbai bench, which held that where the corporate debtor claimed that the amount paid by the applicant financial creditor was towards the equity contribution for a project and produced the ledger account to that effect. It was held that the applicant financial creditor has failed to prove the basic requirement that the amount advanced is a financial debt as provided under the code, because the amount which is contributed towards the equity is always the interest-free amount. Otherwise, it will be categorized in the nature of loan. Second defense that can be taken by the borrower is this can be taken either under the SARFAESI Act, under the RDB Act, or under the IBC provisions, because Section 238 of the codes provides that the provisions of Limitation Act also applicable on the provisions of IBC. For this, you can refer the judgment of Honorable Supreme Court in BK Educational Services Private Limited versus Parag Gupta and Associates, civil appeal number 23988 of 2017, where you can able to understand the concepts and the application of the limitation on the proceedings of IBC, and also the concept of running account in your balance sheets, and also the acknowledgement, when under what situation the acknowledgement in writing can extend the period of limitation. For this, you can refer this judgment of Honorable Apex Court. Next defense, that the application is not filed by an authorized person. So this is an essential condition under the IBC Act. The person who is filing the application must be authorized. He must not be the power of attorney holder that was held by the Honorable NCLAT in Pelogix Infrastructure Private Limited versus ICICI Bank Limited on September 2017, in which it was held that it is only an authorized person, which is distinct from power of attorney holder, who can make an application under Section 7 of IBC. It has been held that the provisions of Power of Attorney Act 1882 cannot override the specific provision of a statute which requires that a particular act should be done by a person in a manner as prescribed thereunder. In view of the same, it has been held that a power of attorney holder is not competent to file an application on behalf of a financial creditor. So this might be the preliminary objection that can be raised. So this we have discussed the grounds, the counters that we can raise before the adjudicating authority. Now, what we should not raise before the authorities, like suppose if you are stating that whatever the money lending and borrowing transaction, there was no express agreement with respect to that transaction. Now, I've referred the case law of Mumbai bench, in which it was held that in which the corporate debtor, who is the borrower, argued that the financial creditor has failed to prove the existence of an agreement as regards to the payment of interest on the amount advanced. So, as we have already discussed, that uh, for proving it to be a financial debt, there must be a consideration of time value of money. So in this case, the financial creditor has failed to prove the existence of an agreement with respect to the payment of interest on the amount advanced. The adjudicating authority held that although there is no express agreement to the loan arrangement or the payment of interest thereon, but there are acknowledgement of the corporate debtor not only once but many a times. Like suppose, being as a borrower, I am paying the installments to the lender, and I am paying the and I'm also deducting TDS on the interest factor which I am paying to the lender. So the deduction of TDS on the interest itself proves that there was an arrangement between me, borrower, and the lender, that the payment will be made considering the time value of money. Then it will be considered as a financial debt under the provisions of IBC. So moving forward, this ground cannot be raised like dispute over amount of default. So the adjudicating authority under the provisions of IBC are only concerned with that there must be the amount which is due and payable, and there must be a financial debt, and the financial debt must equal to or exceeds the threshold limit that is provided under the Act. That is not considered to ascertain the quantum of amount. If suppose borrower is stating that the default amount is not 2 crores, the amount is 1.50 crores only. So the adjudicating authorities only consider whether the threshold limit has been invoked or not, because whatever the objections of the borrower can only be raised before the committee of creditors only after the admission of the corporate debtor into the corporate insolvency resolution process, and not before. Third ground which you cannot raise, that if your company is solvent. So as we see under the provisions of IBC, that the amount must be, that there must be the inability to pay the debt, but the borrower cannot raise that the company is solvent but company is not paying. So in this, I am referring the case law of ICICI Bank Limited versus Jyoti Limited, Private Limited, and company petition NCLT Delhi, in which it was held that if there is a debt and default, and application by financial creditor under Section 7 of the Code is complete, the adjudicating authority is bound to admit the application. Claim of respondent that it is a solvent company is of no ground once there is a default in repayment of the loan to the applicant financial creditor. So you cannot raise this objection that I am solvent, but I am not going to pay to you. You have to pay, and if you are unable to pay, it shows that you are you have inability to pay the debt. So next, that is, now suppose if any proceedings are, now suppose if any lender has initiated the action under the provisions of IBC, and you are taking the defense that because under the provisions of RDB Act or under the provisions of SARFAESI Act, an application on the same cause of action on the same subject matter is already pending, then this is not a defense, because in Unigreen Global Private Limited and also in Yes Bank Limited versus Namo Alloys, it was held that if any action has been taken by a financial creditor under Section 13, subsection 4 of the SARFAESI Act 2002 against the corporate debtor, or a suit is pending against the corporate debtor under Section 19 of the RDB Act 1993 before a DRT, or appeal pending before the DRAT, the same cannot be a ground to reject an application under the code, because of the reason that Section 7 application filed under the code is an independent proceeding which has nothing to do with the pendency of any criminal or civil proceedings. So this you can also refer Section 14 of the IBC Act, which talks about the moratorium period. Once this period will begin, all the entire proceedings, whether under the SARFAESI Act or under the RDB Act, under the same cause of action, they have to face the moratorium under Section 14. So these are the defenses, these are the do's and don'ts that you can raise under the provisions of IBC. So moving forward, now as we have seen that under Section 17 of the SARFAESI, any person can lodge the complaint. Any person includes the borrower as well as the guarantor also. So we need to understand the contract of guarantee, because in the normal borrowing and lending transactions, there is a clause of guarantee also, either as an independent clause or there is a separate contract to this. So what is guarantee? So the guarantee is defined under Section 126, which says that a contract of guarantee is a contract to perform the promise or discharge the liability of a third person in case of his default. The person who gives the guarantee is called the surety. The person in respect of whose default the guarantee is given is called the principal debtor, and the person to whom the guarantee is given is called the creditor. The contract of guarantee can either be oral or written. In very simple terms, now suppose if any lender has extended any financial help or finance to the borrower, and I have given the guarantee to the person, like suppose if the said borrower is unable to pay off the debt, then I will pay. This is a contract of guarantee in a very simple term. But we need to understand that the liability of a guarantor is coextensive with that of a principal debtor, which means that the lender has a right to recover the dues directly from the guarantor without first approaching to the borrower. So you have to be very conscious while giving your name in the contract of guarantee, because in that case, if there is an inability by the borrower, these lenders and banks can directly approach you for the payment of money. So what are your possible defenses as a guarantor? So number one, that is by variance in terms of the contract. So the section 133 of the Indian Contract Act postulates that any variance made without guarantor's consent or had no knowledge or had no knowledge of in terms of the contract between the principal debtor and the creditor, it discharges the guarantor as to the transactions subsequent to the variance. Now, suppose if I have given the guarantee for X amount, and without taking my consent, the amount has been extended by way of enhancement of credit facilities, by way of entering into any subsequent agreement between the borrower and the lender, and the guarantor is not a party, then in that case you are not liable for that additional sum. So for this you can refer the judgment of Honorable Bombay High Court in the matter of Keshavlal Harilal Setalvad and others versus Pratap Singh Mohallabai Sheth and others. You can refer this judgment. Second, release of borrower by the lender. This is defined under section 135, which says that if without the consent of the surety, the creditor and debtor enter into any contract or compromise or agrees not to sue to the surety, then the surety shall stand discharged. This can be explained. I have referred the judgment of Honorable Rajasthan High Court in the matter of Ram Sarup and another versus SBBJ Bank, which states that it is true that in each and every case of compromised surety cannot claim discharge of the liability under the surety bond, but when the creditor accepted that the decree be passed against all the defendants, and this decree is to be satisfied by defendant number one only, and when creditor himself agrees to accept entire decretal amount from only the borrower defendant, then it amounts to voluntarily entering into new contract by the creditor with the debtor. This new compromise or agreement by necessary implication discharges the guarantor, because the because in this case the defendant number one himself agrees for payment of the whole of the amount, then it automatically impliedly releases the borrower, releases the guarantor under section 135 of Indian Contract Act. Moving forward, third is remedy of surety impaired by the act or omission of the borrower. This is defined under section 139 of Indian Contract Act, where the lender either does something which is inconsistent with the rights of the surety or omits to do his duty towards the surety, and because of this the eventual remedy of the surety that he had against the principal debtor is impaired, the surety or the guarantor is discharged. This was held by the Honorable Bombay High Court in Jose Inacio Lawrence versus Syndicate Bank and another, stating that failure in not registering the charge by the banks, because whenever banks is extending any finance to any borrower, then it is the duty to register the charge before either like Ministry of Corporate Affairs or any charge registering authority. And if in case he fails to do so, then this is the act which is inconsistent with the rights of the guarantor within the meaning of section 139 of Indian Contract Act, and the eventual remedy which the surety may have against the principal debtor is impaired, resulting in discharge of the surety. So the next and the last one, that is the guarantee obtained by misrepresentation and concealment. Now, if there is any forgery relating to your signature, relating to the signature of your guarantor, then in that case, the section 142 protects the guarantor, which says that any guarantee which has been obtained by means of misrepresentation made by the creditor or with his knowledge and assent concerning a material part of the transaction is invalid. And this was held by the Honorable Delhi High Court in Krishan Kumar versus Syndicate Bank and others, in which it was held that it was argued that the guarantor did not give any guarantee and had not signed any document undertaking to pay any money to the bank in the event of defendant number one failed to prepay the sum, and the guarantor contended forgery by the bank manager. In this, the Delhi High Court held that finding of the trial court in holding the guarantor liable as much as the principal borrower was erroneous in light of the fact that the plaintiff's bank had miserably failed to prove the authenticity of the guarantee forming the subject matter of the case. So these are the possible defenses when you are in the position of a guarantor. So these are, so whatever I have discussed are the possible defenses with the borrower and the guarantors. So my piece of advice to the borrowers is that at the time of entering into any loan agreements, you must be very cautious, because you must be very cautious about the interest rates, whether the fixed rates have been specified in the agreement or floating rate has been prescribed, the penal interest rates, the security which is held as a collateral against the borrowings, the prepayment charges, what are the events of default in case of a sanction letters or any kind of contractual obligations, the loan is secured or unsecured, because the purpose, because you have to be very careful at the time of entering into the contract. So whenever there is any default, you come out of all possibilities of disputes relating to these contracts or other kind of loan agreements, because at the time of defaults, banks generally have a tendency to inflate those charges, those penal interest, those interest rates. So you have to be very particular. So this all for this session. So now Jay, get back to you.
Thank you so much there, Mr. Rachit Sharma, for your valuable insights on this very important topic issue, which is otherwise very confusing. And congratulations on a brilliant presentation. I'm sure the way you've made it simple for all the viewers, it will immensely benefit all of them. Our email is mentioned on the channel. So in case any of you have any of the queries on fundamentals or concepts with respect to defenses that are available against the guarantor, feel free to write to us. We'll be forwarding the same to our amicus for today's session. So thank you so much, Mr. Rachit Sharma, once again. Thank you so much, everybody. Stay tuned. Next episode is on its way. So it's goodbye for now. Thank you.